Tonight, we're getting a look at what is involved in the process for an attorney seeking to be removed from a case.
Yeah, it's a high-profile case here in the Tri-Cities. A public-appointed defense attorney wants to walk away from it. Brad Sproles has filed a motion to remove himself as Megan Boswell's lawyer. She's accused of killing her one-year-old daughter, Evelyn, whose remains were found on a family member's property in Blountville in March 2020.
Megan Boswell is set for trial in February. In this filing, Sproles said the attorney-client relationship with Boswell is not salvageable and he wants to be removed from the case. And now we're getting a look at what is involved in the actual removal process.
And Kate Nemmer spoke with a well-known local defense attorney about this. Kate?
Josh, Sarah, according to defense attorney Don E. Sproul, it is not unusual for new attorneys to step into cases, whether due to a defendant's request or counsel's motion to withdraw. However, a judge will take several factors into consideration before granting that motion, and it could impact trial timing.
Permissive withdrawal would be where your relationship with your client has devolved to the point where you really cannot communicate, to the point where you cannot be effective as a lawyer. You have to provide effective assistance of counsel. That's constitutionally required.
The judge will take several factors into consideration, according to Sproul, including questioning counsel as to why they want to be removed.
Generally speaking, if an attorney in good standing with the court says, "Judge, I've got to get out of this case. I can't go into it exactly," then the judge is probably not going to make a great deal of inquiry.
The judge will also consider how much discovery has been done and if a trial date has been set.
It's not anything that's unusual for us as attorneys to step in, either by appointment or private hire, to have to come up to speed.
At that time, the attorney will need to get up to speed with the case by reviewing transcripts, the previous lawyer's notes, and potential recordings. It is unlikely hearings would be repeated.
As far as a redo, just to be a redo, no, you don't get a redo, because you're going to have a transcript of everything that happened. And courts rely on transcripts of testimony.
A judge could also grant the motion, but decide not to appoint new counsel.
Some judges will say, well, Mr. Defendant or Ms. Defendant, I'll let this attorney withdraw, but I'm not appointing you another attorney. You're going to be representing yourself. Judges are reluctant to do that, of course.
If the motion is granted, Sproul said the most likely reason a trial would be delayed in this case would be due to a new lawyer's availability.
The only problem is that most experienced attorneys who are going to be appointed to represent this woman will have a busy schedule already and already have a number of trials that are scheduled. We're like judges to some extent. They're looking for trial dates, and so are we.
That motion hearing is set for tomorrow at 9 a.m. in Sullivan County Criminal Court. News Channel 11 will be in the courtroom and bring you the latest.